Well, here we go again. My name is Gandalf. I am the magical Gandalf, and I'm so much better than the presenter will be today. If you've come to see a very nice presentation on planning with and for the family business part 3, then I'm sure that you will not be surprised if it's a little boring. The presenter is a real nerd. He has nothing better to do than to try to give all these webinars, and half of what he says is about half of what he says. He'll actually say twice as much as half of what he says. Now that's for those of you who are mathematical. The rest of you just hold on to your hats and away we go. And please no flash photography or flashing. Thank you. Okay, well that was the best part of the webinar. Here we are today. It is Saturday, August 17th. The history of this business planning webinar is that I gave a 1-hour talk at a Florida bar conference about 4 months ago, and the 1-hour talk turned out to have about 6 hours of slides. So I thought I would just see how long we could make it last. And here we are today. There's a few dozen of you here, not hundreds, but you're the diehards. You want to know, what can we do planning for family businesses? And I'm going to give you more information on that. You can go to our YouTube channel and see parts 1 and part 2 and part 3. We'll probably get up to part 6 before we're done. We've got a lot of neat stuff on the YouTube channel, so please don't hesitate to go there and watch it. YouTube pays me sometimes $2 to $3 a month for your watching those YouTube videos, so just click on that thing as much as you can. We need the money. Secondly, if you have a question, then that's great. It means you're listening. You go to the inverted question box, click on it, type in your question, like when will this darn presentation be over? And then I'll answer your question during the talk, most likely. I'm a big proponent of running the numbers on estate tax planning. We'll show you some numbers at the end of this presentation using the Estate View estate tax planning library. If you are interested in buying Estate View, please do, because we have terrible cash flow problems. Just send me an email if you want a 10% discount if you buy it today, and I'll guide you through how to do it. There is a 30-day money-back guarantee, mostly for those of you who forget that when the 30 days is over and don't get your money back. The most popular brand is $4.99 a year. If you're a tax professional and this isn't worth $4.99 a year to your practice, then I'll be surprised. But I know people are short on time. So where are we? We've talked about setting goals and having competent team members. Sometimes the most valuable thing that you or I can do for a client is introduce them to other people who can help us do what we do. I'll be the first to say that in our law practice, which has on average 7 lawyers, we are calling in other law firms to help us literally every single day. And our clients are thankfully understanding of that and actually like that. Back in the old days, in the 80s, you would not admit that you needed help from another lawyer, and doctors didn't even have a lot of specialties back then. But now it's a wonderful thing to say, I've got a great relationship with a securities lawyer who can look at your offering and make sure that it's not going to mess up your entire life. Then we discussed that asset protection is usually a very good motivator for good reason. But there's all kinds of good tax things and cleanup things and reduction of risk things and helping of estate planning motivated by creditor protection. So whatever it takes to motivate, let's get the right stuff done. Number 3, you have until December 31st of this year to register every darn company under the sun, 37 million of them with the Treasury Department, $591 per day fine beginning January 1st of next year if a company is not properly registered. There are exceptions for big companies, but most of our clients' companies are registering. It is a pain, but it's not impossible. It needs to get done. There's confusion over that one federal court case where the judge enjoined the act only for the parties to that case, not for everyone else in the United States. And then there's confidentiality planning. When we get a new client, we go to Google, we go to the Secretary of State, we show that client all the stuff we know about them before they tell us anything. And they say, wow, can you change that? And of course, the answer is sometimes yes. Then we talked about estate planning. That's an important aspect of business planning. You can't have one without the other. And then we talked about inheritances, and I think that's where we were. So I'm going to go to page 125 of the outline. And if you did not get the outline for some reason, or it's a PowerPoint actually, let me know. And by the way, we discussed that in 2026, the estate tax exemption goes to half. Use it or lose it. Start getting ready. I know everybody's going to wait for the election to be over. Once the election's going to be over, if the Democrats have a good result for the Democrats, then estate tax lawyers are going to be very busy and even more popular than we are now, believe that or not. Okay, so we talked about estate tax planning, probably ad nauseum from your point of view. And then we talked about the basic structure of when I die, I leave my business to one big trust that takes care of all my descendants, and there's some sort of rules of governance relating to that. By the way, commonly that's the oldest child in charge. Good luck to everybody else. That doesn't always work that well, by the way. Or do we do a separate trust for each child and they share ownership of the company? Who's going to be in control? Is that child who really runs the company going to own more than the others and owe promissory notes to the others? What's going to happen to the company? What's going to happen to the company real estate? There's no one plan for this. Everybody, we lay it out for the clients, and then they make the decision or the indecision. And I gave you language. I even gave you language for sibling controlled businesses, which I don't know how many psychologists that takes, but there are a lot of successful sibling controlled businesses, including that Firehouse Sub, the Sorensen business, which were an important tax court case. I could only hope that one of my clients someday becomes an important tax court case. My clients would much rather not become an important tax court case. And then there's the protective trust logistical system. I think this is where we were last week. So typically you have a married couple and they're very happy together. And they may have separate revocable trusts if they live in most of the states of the United States. If they're in California, Texas, Wisconsin, Arizona, or one of the other community property states, they may have a joint trust. Or if they want a full step up on their assets on the death of the first dying spouse, they may try to set up a joint exempt step up trust called a jest. But I'm doing some estate planning right now for a client who is very, very successful. Millions of dollars a year of income from a company that this particular spouse set up. So this particular spouse is going to place that company that might be worth $100 million in his or her revocable trust. And that revocable trust says, on my death, if my spouse survives me, distribute not more than the estate tax exemption amount, today being $13,610,000, to a trust for the education of the descendants of my grandchildren, to my friends, to my neighbors. Also give to whatever I want to go to charity when I die, because I have a large estate and I don't want my surviving spouse to muck it up. But everything beyond that can go to a separate trust called a QTIP trust, Qualified Terminal Interest Property Trust, which will qualify for the federal estate tax marital deduction. So on the death of this client, if the business is worth 100 million, 13,610,000 of assets can go to this stuff, take care of the spouse, take care of the children, take care of those specialty distributions. And everything else, about 86,490,000, will go into a marital deduction trust. There will be no estate tax on the first death. The price for this is that the surviving spouse has to receive all income from that trust, whether he or she deserves it or not. And then on the second death, this trust is going to be in what we call in the business deep doo-doo. Because on the second death, this trust is going to be subject to federal estate tax. Now, when I graduated law school in 1983, the estate tax exemption was $325,000, and the estate tax rate at $2 million was 55%. So those of you who think you have it bad with a 40% estate tax rate over 26 million per couple, you might have it pretty good. Brandon Ketron and I just issued a newsletter for Lineberg Information Services on what to do with these huge QTIP marital deduction trusts. The answer, of course, is call us, but actually read that Lissy article, because you can make it into what's called a 678 trust and maybe limit its growth. So where does the life insurance come in? The life insurance may come in the form of a separate irrevocable life insurance trust. Let's say that this client is concerned that his or her spouse may not survive. There may not be a marital deduction. So then you're going to have an estate tax of let's say 40% of 83 million, a $32 million estate tax. That's not a good day. So maybe this client would like to put a $40 million life insurance policy in place under what's called an irrevocable life insurance trust. And how would you pay for that? Well, the business may pay for it by what's called a split dollar advance arrangement, where the business actually pays the premiums and the business will get the premium dollars back plus a little bit more maybe when the client dies. So, big picture here is, where are you putting your business entity? Another alternative is that this business entity could be owned jointly by the two spouses. And if they reside in Florida, Delaware, Tennessee, Wyoming, or one of the other tenancy by the entirety states, the advantage of that is that if one spouse gets sued because the sports car accidentally kills a school bus of children, then you don't lose the asset. But on the other hand, if you own it jointly with survivorship and you die, then your spouse owns it on the second death. And your spouse may give it away to somebody who you don't know or like. If your spouse is a male, then usually he'll give it away to somebody you knew while you were living who was actually at your funeral. But that's another story. So all these things should be thought through, as well as, of course, the estate tax planning, which I will hit a little bit on that on the hour when this show is over in about 46 minutes, which will seem longer. Okay, so where can I put these assets? I've got the first spouse's revocable trust. By the way, it's not protected from creditors there. I've got tenancy by the entireties. I've got spouse two's revocable trust. I've got an irrevocable trust for those adorable descendants. And then I've got a spousal limited access trust ability. So I could put $13,610,000 into an irrevocable trust today for Marcia and our descendants. By the way, I can give my father-in-law the power to appoint trust assets to creditors of his estate under this trust, and then when he dies, all the assets in the trust get a new income tax basis. My creditors can't touch the credit shelter trust. Marcia's creditors can't touch it, even though she's the trustee and gets what she needs for health, education, maintenance, and support. Marcia can direct where the trust assets go when Marcia passes away. She could direct them back to me. I know she probably won't. And then we could even have a floating spouse provision, which would say that if we got divorced, which would never happen, she would kill me first. But if we did, then maybe that would divide into one trust for Marcia that I would have no voice in, and then another trust for our descendants that my next spouse might be a beneficiary of. Of course, when Marcia and I drafted our SLAT, she did not want a floating spouse. So there's no floating spouse provision in there. So that'll be sink or swim, I guess. Now, the next layer is, where does the business go? Does it go under the revocable trust and then partly under the gifting trust to take advantage of charging order rules, multiple ownership, and discounts, which we may talk about? But you'd be surprised at how many clients walk into our office with nice documents, but no thought or actual knowledge as to how are you going to own the assets or the entities under these nice documents. And then there's the Jest Trust, as I mentioned, and you can Google Gassman Jest, J-E-S-T, and it's a way that I could own 3% of the Jest Trust. Marcia could own 97%. It could own our buildings. It could own various assets. And then on my death, it gets a new fair market value income tax basis, even though my creditors could only reach 3% of it while I'm alive. So it's a little bit progressive. It's not on everybody's radar, but some law firms are using them and others. And then if you put an LLC underneath the Jest Trust, partly owned by an irrevocable trust, and the irrevocable trust has half of the voting rights, then on death, we may get a discount if we want a discount for for estate tax purposes. And then if you get a judgment against me and Marcia, you can't reach into the LLC because of the Florida charging order protection rules. So, and then sometimes we set up separate Jests, not at all unusual. The business goes under Jest number 1, irrevocable. So Marcia and I can't take the business away from our child who runs it as we get older, but we could benefit from it. And then when one of us dies, there's a step up, so the business could be sold without capital gains. And then we put the building and the investments in the second irrevocable trust for our other child. And the children may not get along and they may not trust each other, but it's going to be hard for one child to commandeer everything. And there's Mark Twain, one of my favorite authors, who said, whenever you get two people on a raft, things go well between Huckleberry Finn and Tom Sawyer. But when you get 3 people on the raft, it's a mess every time in the book Huck Finn. So, and especially when Amy shows up, she's so pretty. All right, so then I like to talk about the marital asset preservation system. And I don't know any other law firms besides ours who talk about it this way or who do them. I'm very interested in any of you who might. By the way, somebody said my audio was gone at 11:16. Is it working? Okay. Neil, thank you for letting me know. We were just playing a trick on you. So here's the marital asset preservation system. It's very simple. You sit down with the client at the end of the meeting and say, by the way, do you realize that if one of you dies, the survivor can give it all away to anyone they meet? What? Yes. You own things jointly. Oh, we do? What can we do about it? Well, you could put it all in complicated trusts, or you could sign an agreement that says when one of you dies, the survivor will set up an irrevocable trust for the benefit of the survivor and descendants, and the next spouse will not be a beneficiary of that trust to the fullest extent allowed under the confusing state law. And that I call a marital asset preservation system. And one thing I really like about it is that it gives me a business reason when one spouse dies to set up an asset protection trust for the other spouse, because so often we represent a physician and the physician's spouse. Everything's in tenancy by the entireties. It's all nicely protected. Suddenly the spouse dies. That's sad. What's sadder for the surviving spouse is, oh, I have all these earnings. I have all these assets. How am I going to protect them? Well, we'd like you to put together an asset protection trust. Well, maybe it's too late. I'm being sued. Or maybe I'm not smart enough to do that. Or maybe I can't focus anymore. Well, this agreement with your spouse says you have to set up an asset protection trust now. So let's set it up. It's called for under the agreement. We even have a provision, I don't know if it'll work, but hopefully it'll work. People are following them, which says if I leave a large IRA to Marcia, Marcia agrees to manage it in a fiduciary manner and to leave it to our descendants. It's an agreement, legally binding and enforceable by our descendants, who are what's called third-party beneficiaries, which for my kids, a third party, they go to parties all the time. But if you're a third-party beneficiary, then you can make sure that your parent doesn't put the whole $10 million IRA into Bitcoin or spend it on the next spouse. So now, will that invalidate a rollover IRA? I don't think so. I don't know for sure. So there's lots of unknowns. But the tax unknowns should not cause us to not address the business of life unknowns. Maybe we'll write a poem about that sometime. All right, so we talked about inheritance trusts. We talked about finding income tax basis using older relatives or people with shorter life expectancies. And I don't think we've spent much time yet. Oh, by the way, sorry, Jeff, there's no continuing education credit for this webinar. If you want us to confirm that you attended, we'll be glad to do that. But we have not registered this for continuing education credit, mainly because it's simply not good enough. All right, here's another thing that we do a lot of, and I'm looking at one of these right now for a client that's going to be quite substantial. So the client comes to you and you have a company. And of course, you want to protect the company. It's the most important thing the family owns, and it's owned directly by the client or by the revocable trust, partly by the client, partly by another investor. And there's no creditor protection. There's not a lot of debt against the company. And if somebody gets a judgment against the client, they're going to own the company. So, and the company has a lot of valuable things in it. It's not only a grocery store, but it owns all the furniture and equipment. And it owns a $500,000 antenna for some reason that no one understands why. But it's in there. It owns the real estate that the darn store is on. It sells liquor on Sundays. And it owns real estate and a cell phone tower. What am I going to do? Well, you call the CPA and say, I need to move that out of there. The CPA says, if you do, you'll trigger income tax, because the CPA did not take reorganizations at the University of Florida LLM program from Professor Lind in 1983 when I did. When Professor Lind on the very last day said, by the way, let me tell you something really useful. You can set up a new S corporation to own your S corporation. It's called a new parent, F as in Frank, reorganization. It's a tax-free thing. It's really easy. You transfer your S corp into the new parent company. It becomes what's called a qualified subchapter S subsidiary, having nothing to do with Firehouse Subs. And then the new parent company assumes the identity of the existing operating company and can set up a new subsidiary which can own the cell phone tower and the real estate and the meat clicking machine and the darn delivery truck. Or you could have several of these subsidiaries, and it's tax-free. And then if you make the holding company an LLC taxed as an S corp, you can get charging order protection. And we are commonly using Wyoming. Why? Because Wyoming is less expensive and easier to use in our experience than Delaware. And Wyoming, when you go to the Secretary of State and say, who's the manager? They don't know, they don't tell you. Who's the owner? They don't know, they don't tell you. It's just like your kids when they come home at night. You don't know, they don't tell you. So that is what we call the over easy LLC arrangement. There's no need to change the name or tax ID number of the subsidiary entity. Even if it's a medical practice, you have to comply with state law, but it keeps its tax ID number, it keeps its Medicare number, it keeps its contracts. You tell Medicare that there's a new owner of the company, but that does not cause any problems for a medical practice. If it's a regulated entity, such as it owns an airplane, you got to tell the FAA. They typically don't mind, but I mean, you have to tell everyone what you're doing. You may have to re-register it if it's a professional roofer or contractor with your state authorities. But in any event, it keeps its name, it keeps its ID number, it keeps its fictitious names. But now the new parent company can loan money to the subsidiary and get a lien on the assets. So now Smith Store Inc. owes $600,000 to Smith Holdings LLC on a 5% note, pays it $30,000 a year. Smith Holdings records a UCC-1 against it. So now when that store has a big lawsuit against it that happens after we did all this, the accident happens after we did all this, the first dollars go to the parent company when the business is sold to related parties. And maybe they do that as part of a bankruptcy reorganization. So the new parent company could own life insurance, enter into buy-sell agreements. It's the best thing since sliced bread. The disadvantages, you have to pay your lawyer and accountant to figure it out and do it. So you have to take one thing and consider it with respect to other things. I'm getting so many more clients who come in and they went to LegalZoom and they made their own LLCs and they made it wrong. Now, I'm sure that it's possible to do your LLC properly on LegalZoom, but I know for a fact it's possible to do it improperly. Does LegalZoom understand tenancy by the entireties? I really doubt it. Does LegalZoom understand that if you want to have an LLC taxed as an S corporation, you cannot have capital accounts or anything unequal or disproportionate or any ability to buy stock for less than book value? I don't think LegalZoom knows that, because I've read operating agreements prepared by smart people on LegalZoom that violated that rule and caused inadvertent loss of an S election, which is really bad. That's probably worse than a divorce for a lot of you, depending on your marriage and your S corporation. Forced sale provisions. So be very careful on the LLC. When we review LLC operating agreements prepared by, knowledgeable law firms, maybe even our own, there is an error rate. You can't be too careful with the LLC operating agreement. And by the way, for Canadians, and not because you're hockey fans from the wrong border, your government treats LLCs like C corporations. So if you have a Canadian investor and they're coming in to an LLC, they need special advice. And hats off to Canada, by the way. I'm not here to criticize Canadians. I'm just helping you keep the Canadians out of trouble. And then your buy-sell agreements. The best advice on the buy-sell agreement, by the way, is read it. And if you don't understand it or you're not following it, then there may be an issue. So now, how do we own this business entity? One way that a lot of clients own their business entities nowadays is under what we call Nevada trusts. Now, there's, I think, 21 states in the United States now that say that you can set up a trust for yourself and your family. You can be a beneficiary of the trust. And according to the law of that state, creditors cannot reach into the trust. The strongest states for this with the most history are Nevada, Alaska, South Dakota, and Delaware. Those are the states that we're knowledgeable on. We've done them in other states. We've done them offshore. They're stronger offshore for sure, but it doesn't do any harm for me to have 96% of the non-voting membership interests in my business owned by a Nevada trust company as trustee under a Nevada trust, even though I may be a beneficiary of that trust, or perhaps I'm only a beneficiary of the trust if the trust protectors add me. Because now if I get sued, my creditors probably have to go to Nevada to get hold of my stock. And by the time they get there, the Nevada trust company may have resigned, and the next trust company, which might be somewhere else, far from Nevada, such as Alaska or even farther than Alaska, may be the trustee at that time. So if you're single or you don't have tenancy by the entireties, I would consider that. We just use Nevada because we're more accustomed to Nevada. There's nothing wrong with the other states. There's all sorts of advantages and disadvantages. If you use Alaska, then when you make a contribution to the trust, the client needs to sign an affidavit under penalty of perjury that the client is solvent after the transfer. And that's fine because your client should be solvent after the transfer. Now, if we put half the voting stock of this company, so 0.5% voting in an irrevocable trust for those lovely children, 2.5% non-voting, so it owns plenty, and then the client keeps 0.5% voting, so nobody can take over the control of the company. The client owns 0.5% voting, 0.5% non-voting. Nevada Trust owns 97% non-voting. Now the client gets sued. The creditor may get 1%, but will not be able to take over voting control. The creditor may be able to set aside the Nevada Trust. The law is not clear, but then all the creditor is going to get under Florida law is a charging order. The charging order says you have the right to 96% of any distributions that come from this LLC, but the court has no authority to require a distribution. It's not a cakewalk. You don't want a charging order against your company, but many plaintiff lawyers looking at this will say, let's settle this lawsuit. I want money. I don't want a charging order and a client to call me every month the rest of my career asking what's going on with a charging order. So if that's helpful. Now, if your client is from Virginia, you could call this North Virginia, Virginia and North Virginia. But what I wanted to bring to your attention is there is no state of North Virginia. There's Virginia and there's West Virginia. So that's how you can always remember that this is voting and non-voting and not Virginia and North Virginia. I think Ogden Nash wrote a poem about somebody named Virginia. I don't remember how it ended though. So we talked about the new parent F reorganization. This would be common. A lot of you, there's about 85 tax professionals on this call right now, plus my friend Robert, who always has great questions about SBITs. So this is common. I've got the widget business. They make the widgets. And then I've got the business that sells the widgets. I want to separate that from the factory. The factory sounds dangerous to me. And then the factory is a building. So I'm going to have a triple net lease, and then I'm going to mortgage the heck out of this building, and I'm going to have the widget business guarantee the mortgage. So, but I want the widget business to have a lot of debt. And the CPA tells me that it can only owe $800,000 because that's the basis of the stock. I want it to owe more than $800,000 because it has $1.8 million in assets. So I set up the new parent F reorganization, and I have it owe $800,000 to the family LLC, which is obviously in North Virginia because it has voting and non-voting. And I have a $500,000 debt now owed to the new parent company. So now when somebody gets hurt, first of all, hey, it happened in the factory. The factory is a separate entity. The factory charges us as an independent contractor. We're not responsible for the factory. Oh, well, you did slip on a widget that we sold you? Okay, well, we'll go ahead and sell all the assets of the widget company in bankruptcy to my mother's trust, and we'll get most of the money to repay our promissory notes. Or would you like to settle for our limits of liability plus $400,000, which is what Alan would have charged us to write a letter? Actually, I write letters for less than $400,000. Now, here's another one, and this one has to do with factoring. So first of all, you've got orthopedic surgeons, neurologists, certain other doctors do a lot of personal injury consulting work. And what happens there is the people get injured and the doctor does the work and doesn't get paid by insurance and gets paid when the suit settles, and the suit normally settles 3 to 4 years later. So a doctor who maybe earns $800,000 a year typically has $3 to $4 million of accounts receivable tied up in her medical practice. And if she gets sued for malpractice, she could lose those. So we set up a new holding company. We make sure we comply with state law. We have the holding company own the medical practice entity. We move that expensive equipment. Remember the Monty Python skit, the machine that says beep? Stop using the machine that says beep. The hospital administrator is going to come and make you shut it down. It's too expensive to run. Put that in a separate LLC. And then we have the factoring company. Now, the factoring company is owned under the same S corporation parent company, but it borrows money from the family LLC. So the family LLC, which is owned 95% by the trust for those beautiful children and grandchildren, loans money at 14% interest to a company, $3 million. The company pays the practice $3 million, and now it owns the accounts receivable. So that is not a taxable event because it's still under the same S corporation. What is a taxable event is that this S corporation now has an interest deduction based upon a 14% rate of return where it's paying interest to the family LLC. And the children, maybe at their bracket or the parents' bracket, are getting interest income at 14%, so that this is growing to avoid federal federal estate tax. It's a legitimate business purpose. So now, what have I done? I've made these children happier. I've protected $3 million of accounts receivable. I've set up a little bit of homework. The comptroller of this practice once a month has to go through the new accounts receivable, the long-term accounts receivable, and then sell them at, say, 85% of their collectible value, whatever the statistical value is, to the accounts receivable factoring company to keep that separate. So a lot of businesses can use this because a lot of businesses, in fact, we have these going with construction businesses because even large contractors get paid when they're done and may have $100, $200 million of receivables that they don't want exposed to their creditors. So that is the new, that's what we call the ELOPE system, the Extended Letter of Protection Enhancement System. You can elope with your accounts receivable. I had a almost disturbing experience in 1989 when a physician client came to me, very sad. His name was Dr. Miranda, and he had lost his spouse in a terrible, awful car accident, and he wanted a second opinion on the plaintiff lawyer, because the plaintiff lawyer got a multi-million-dollar judgment against Kane Furniture Company, which is about 2 miles from my office, still in existence, and wasn't able to collect it. And the reason was because Kane's Furniture Company had multiple furniture stores, and they had set up a separate company to do the installations of carpet and to move furniture. So this driver of a Kane's Furniture truck, which said Kane's Furniture on it, who went for a cocktail or two and then back onto the road and rear-ended Dr. Miranda and killed her, was found to be an employee of the installation company. And it was found that the truck was owned by the installation company and that the Kane's Furniture mothership was not responsible for the death. Even though the clients, even though the person that this truck driver was on the way to go help was a Kane's Furniture customer who didn't know anything about the fact that this was a contractor. So that was a sad time for me to learn how that worked against Dr. Miranda in, I think, 1989 or 1990. But that is the law of the state of Florida, and that's the law of the state of most states. So when I meet with a client, which is, commonly, you meet with a client and you go, oh, you've got 3 locations. How do you move parts and stuff between those 3 locations? Oh, well, the driver in the truck. Oh, the driver in the truck is driving stuff between these 3 locations. Yeah. What happens if there's a terrible accident? Oh, well, I guess we lose everything. We have insurance. Okay, how much insurance do you have? 5 million, 10 million, 20 million? Guess what? An accident can easily cause $100 million of damage. So how about letting your uncle have a trucking company that handles the truck and paying your uncle as an independent contractor? The Sykes v. Dana Highlight case, 1985. A lady goes to park her car at the Highlight Fronton, gives her key to the parker guy, I forget what you call those guys, and he ran her over. And so she sued the Highlight Fronton. The Highlight Fronton is a gambling place with a game they play called Highlight back then. Well, the court said, sorry, he was working for a separate company owned by the Highlight Fronton. He was working for the parking company. So guess what? You have your judgment against the parking company. You get all, the key holder there, you get the key holder. So you can do this. For example, if you have a plumbing company and they do residential plumbing and they do construction plumbing, well, set up a third company that owns the trucks and the employees. And then this third company is responsible if there's a problem. And half the time, this company is doing stuff for the construction end. Half the time, this company is doing stuff for the repair end. But if there's a horrific accident, it's clear that the driver is only working for one or the other at that time. So our first line of defense is you can only sue the employee vehicle company because they have an independent contractor agreement whereby independent contractor relationship, they're providing the construction services and they are providing the repair services. But then if the plaintiff lawyer breaks through there, you may lose repair or you may lose construction. You won't lose them both. And then if there's plenty of debt owed to the family holding company, then, hopefully this will be something that the family and the family business will survive. Another example here would be a solar company. So you've got sales, put the salespeople in their own company, independent contractors, have it owned 15% by the key salespeople. They'll talk all day about it. They can drink coffee. They can go have their events. They're independent from the installation company, which is independent from the company that owns the intellectual property. Set up a franchisor company. It's not hard. Set up a franchisor company to own the intellectual property. Aspire to be a franchisor. Transfer the assets, the name, the know-how, the protocols. Get all that out of the operating company. Have the operating company license it. Is it overkill? It's not overkill on the day that the accident happens. It's only overkill until then. So I can go on and on. Buy-sell agreements. We had the Connolly case. The U.S. Supreme Court is getting involved with tax cases and business cases, and given how opinionated this Supreme Court is, we may have some really nice pro-taxpayer decisions coming in the future. I don't know how familiar everybody is with the Loper case or the Loper case. I read it, I don't know how to pronounce it. But the US Supreme Court said when the IRS writes a regulation, they're not necessarily right. We had something called deference, where the deference doctrine was if the IRS writes a regulation under Internal Revenue Code section 7805, they're probably right. That was the Chevron case. They're probably right. You got to, if the IRS said it and it's a tax law, they're probably right. Well, the US Supreme Court basically said for a lot of these regulations, there's only one right answer. And the answer that the IRS put in the regulation is, by my view, almost presumptively wrong, because the IRS, when they write regulations, and this isn't a criticism, this is a compliment, when they write regulations, they're trying to do what's right for the government, not what's right for the taxpayer necessarily. Regulations have never been, oh, this is completely fair and equal. We represent the government. We're supposed to collect taxes so we can operate the government. So now all these regulations that we've been following since I started practicing in 1983, going back to 1954 and before, they're now in doubt, a lot of them. So we may see situations with basis when grantors die of grantors' trust. It will be very interesting the next 5 years. But what happened in Connolly was that these people put life insurance into their mother station company, which I never like to do, and they did not have a really good agreement. In fact, they had a kind of a not a good agreement, and Connolly died, and the IRS said, hey, when you died, the company was worth more because your life insurance was in there, so you're going to have to pay us estate tax on what that company was worth with the life insurance, even though you got a lot less than that for the company when you died. So there's all sorts of 1-hour talks on Connolly. You can write a book about Connolly. But I think the main takeaway from Connolly for me is consider either a cross purchase or a trusteed entity buy sell if you're going to use life insurance. So I have shareholder A and shareholder B, and they have a company and they would like to buy life insurance and have life insurance. So if one of them dies, the survivor has plenty of money to buy out whoever died first and also have extra money around to run the business. And that's called key person life insurance. So if I own the life insurance on Crotty and Crotty owns the life insurance on me and I die, how can I be sure that Crotty is going to receive that money and actually pay it to Marcia? How do I know that he's not going to be in an accident or angry at me or in a divorce? And we've seen this happen. We've seen situations where shareholder A dies and shareholder B says, I'm mad at shareholder A. I'm not going to pay it. Forget it. You can go to the end of the world, all that stuff. So you put it in the company. If you put it in the company, then the company may lose it to creditors. So what we like to do is you set up a separate LLC. And this is specifically condoned by the IRS. At least they approved it once in Private Letter Ruling 2007 47002. You see there at the bottom. And this LLC, you want it to be taxed as a partnership. You may put a desk in it. You may have it own a publicly traded partnership that you would buy from a brokerage firm for $10,000. But that LLC owns the life insurance on A and B. And the LLC agreement and the trustee agreement says if A dies or B dies, the money goes to the LLC. The trust company comes in and takes the money and holds it, or the law firm comes in and receives the money and puts it in the trust account, and it does not get loose until the rules are followed. And this enables the surviving shareholder to have a basis in the stock being purchased based upon the life insurance. So in other words, if I do a buy sell with Crotty and the million is in our practice and I die and Marcia gets the million, his income tax basis in the stock that was purchased is just what his basis is in our corporate stock. On the other hand, if I die, he gets $1 million, he pays Marcia $1 million, now his income tax basis in the stock is $1 million. Or if we use this buy-sell LLC arrangement under Revenue Ruling 2007 47002, he can get the $1 million basis. How do we pay for the life insurance? Well, he could pay for mine, I could pay for his, or the company, our practice could pay for the life insurance, and it could get the money back for its premiums if we're buying permanent life insurance. So that's what I like to say about the cross-purchase agreement. By the way, if you're using the Estate View software, that'll give you life insurance numbers, or you see some life insurance numbers here as far as for a 40-year-old standard 10-year term per million, $925 a year. Why wouldn't you have this insurance on somebody who's 40 years old? If they're healthy, non-smoker, they may die. Why wouldn't you have plenty of life insurance, at least term life insurance, to handle stuff like this for if people pass away? That's, of course, a rhetorical question. Okay, if I have any questions other than that. Okay, let me answer a couple of questions. I want to thank everybody for being here. I've only lost 2 people since we started. Probably my best friends. With the F reorganization, will there be transfer taxes on the real estate? John, it all depends. If you're transferring real estate, in Florida, you can avoid the transfer tax by transferring the real estate directly to a subsidiary or parent wholly owned by the real estate owning entity under what's called the KERO case, K-E-R-O. In other states, it will vary, but that's a good question. When you transfer real estate, you have to remember there could be a documentary stamp tax. James says, reversing the Chevron regulation case was a great decision. The government and its agencies have moved without congressional approval to greatly expand the reach of government. Congress, unfortunately, delegated too much authority to the executive branch. Yep, okay. Everybody's entitled to their opinion, and thanks for voicing it. Then, is part of your practice knowledgeable on international law? I am knowledgeable to know to call an international lawyer when I have an issue of international law. But I will tell you that it's good to try to find a lawyer who was educated in the United States who's now practicing in the country that you want advice on. That, to me, that's the key. I want somebody who understands the US system to relate to to our system, and somebody who's pretty good with English and actually answers emails. That's what I know about international law. And I know that Leslie Share, S-H-A-R-E, is a fantastic lawyer in Miami who often gives me great introductions to people all over the world who can hopefully help us. All right, so now we've got 5 minutes, which for many of you is 3/10 of a billable hour, I know, to talk about choice of entity. Now, you know, back when you were dating and you would have to go to bars to find people to meet or wherever you would go before the internet, there were fewer choices than there apparently are now. But the choices in entity selection when you're going to start a new business are not uncomplicated. Let's put it that way. And the qualified small business provision under Internal Revenue Code section 1202 enables what we call a C corporation to be formed and operated, and then for the owner of the C corporation to sell the stock, depending upon the year, completely income tax free, or depending upon where you are in the tax law that year, at a much lower rate. So the rage in Silicon Valley is you set up your company as a C corporation, planning to sell it income tax free, and that is under section 1202. On the other hand, though, that C corporation is in the 21% income tax bracket, and that goes back up in 2026 to the highest bracket. What was it, 38%? Plus you have state income tax in Florida, that's 5.5% at the C corporation level. And then if you want to take money out, you're going to pay a dividend tax. The shareholder is going to pay another tax, which is typically going to be at the highest individual rate, 37%. And then you may pay another 3.8%. So this 1202 C Corp is great if you're not going to pull money out and the company's not going to have income. But if the company's going to have income and you're going to pull it out, then you typically want it to be under an S corporation. And the reason you want it to be under an S corporation is because S corporation dividends don't have employment taxes and don't have the Medicare tax. So that saves you 14% employment taxes on average, plus a 3.8% Medicare tax. But then when you go sell your S corporation stock, you pay capital gains tax. So which do you do? Do you do the 1202 C Corp or do you do the S Corp? And an interesting answer that I got from a recent study, and by study I mean the client said, what should I do? And I said, I don't know. And he said, ask around. And I said, okay, I will. So I asked around and I came up with something a little bit creative. And that was, we will put the widget factory itself under a 1202 C Corp, and we will put the intellectual property and the management and the sales team under an S Corp. And we will have reasonable profits under the C Corp, but not more than we need to have. We'll have reasonable profits under the S Corp. We'll have to pay reasonable compensation. We know that. But then when this thing sells, if the buyer is willing to buy stock, we'll allocate as much as we can to the C Corp and as little as we can to the S Corp within reason. Or if the buyer is only willing to buy assets and wants nothing to do with buying C Corp stock, then we'll allocate as much as we reasonably can to the S Corp and as little as we reasonably can to the C Corp. So that's, I don't know what we're going to call it. Maybe we'll call it the dueling 1202 S Corp regime. But I think that is a workable way, and I think it's good to have the conversation with the client. Now, as I mentioned before, with an S corp, you cannot have preferred stock. You cannot have capital accounts that are different between the partners. So if you're going to have a flow-through entity, and the flow-through entity is going to have those special characteristics, then you want to go with an entity taxed as a partnership. But then you may have issues with having to pay employment tax on the income, because if I'm working for an entity that's a partnership and I get a K-1, that may be subject to employment taxes. It may be subject to Medicare tax. So maybe I'll form an S corporation that I'll own, which will own my 40% of the partnership. And of course, these considerations go on and on. So I've given you some literature on 1202 companies. 1202 companies can't do any of the following things, just like the Section 199A. Now, let me see if there's any other questions. See, I could go on for probably 60 days on this outline. Okay, we asked about, do I know about Columbia law? I know that Columbia Law School is in New York, and I know a reputable law firm in Columbia that I can recommend. If anybody wants their name, I just worked with them. They were very friendly. Okay, would Connolly apply to the insurance LLC from Stewart? I don't think so. The problem with Connolly was the agreement was not nearly as well written as it could have been, and that is to say the least. All right, so let me show you something I was playing on with Estate View. Let me get Estate View. Come on, Estate View. Move over from screen to screen. So thanks for sticking around. This is Estate View software. You go to estateview.info and you can look at our website. Then you go to estateview.link and you could buy it, and it's 30-day free approval. And if you want a discount, call me. By the way, what's in the tax news? I'll click on tax news. And when you click on tax news, you can watch 4 different tax news things. Biden administration increased tariffs. Super luxury cars go electric. I can just pick whatever news feeds I want. And then I can also look at the summaries. So that's neat. But what I wanted to show you was this client I'm working on. Give you a little background on them. First name, Bob Sample. Now, that's not really his name, but born in 1979 and has found a really, really neat business model, well matched with an extreme intellect and a wonderful team, earning $30 million a year. And I think that he'll be able to earn $30 million a year at least another 10 years. And this is only the beginning. This could go to 300 million. But I'm going to show him numbers at 30 million a year. Married to a very nice person who is also a very important individual in the business. And I figure that when they finally retire, they'll be spending a few million a year. But they're not going to be huge spenders. They're very generous with charity, though. So there will be a lot of spending when they retire. But people like this typically don't stop making money. They just know how to make money. Now, if they want life insurance, I can click on life insurance estimates, and then it knows their ages and it knows how much per million life insurance may cost, just so I know. I'm just showing off that button, by the way. And the exemption probably going down by 50% in 2026, maybe. We're going to set the estate tax rate at 40%. We're going to say inflation is going to be 4.21%. That's for the exemption going up each year. Real inflation, let's say, is going to be 4.5%. Inflation's up. And then I'm setting their business and investments at 100 million. I would never sell what they own for 100 million. Let's go ahead and let's move that up to 140 million. That's probably more like it. Growing at 7%. paying tax at 2% of 140 million per year, a modest $5 million home for their situation. And they may do qualified personal residence trusts. I'm just going to show them so I can show them off. I could do a 12-year QPERT for each of them. And they would like to do a credit shelter trust on death, just to show how it works. They would like to do annual gifting for their 6 children. By the time after 11 years, maybe they'll have more children. They'll have in-laws and outlaws and all that stuff. We'll leave life insurance out of it for now. And then they may want to give a large gift this year to use up their $27 million exemption. And also, they may do an installment sale. So let's see what the numbers look like for them. I'm going to start off with die in year 1, no planning. And die in year 1, no planning, $49 million of federal estate tax if they both die this year. So I recommend that they not both die this year. And $102 million goes to the children. That coincidentally is $25 million per child, which is one of the parameters of this planning. They want each child to get at least $25 million, and above that, they're happy for everything to go to charity so they don't have to pay any estate tax. So we're going to talk about how that works. Now, with planning on death, if they want no estate tax and they die this year, then I can get their children $62 million, and I can have $89 million going to charity. So that's not going to really work for them because they want $100 million to the children. So they would end up paying some estate tax. And I can toggle to tell them what that would be. I can just toggle this to get to $105 million to the children. The estate tax would be $28 million. The children would get $105 million, and the charitable lead annuity trust would get $17 million. So based on the documents that I've been working on this morning, this is what would happen if they die this year after they sign my documents. But they plan to live 32 years. So let's go to no planning, 32 years. Now, they start with 140 million. They're adding 30 million a year for 10 years. Then they start spending $1,625,000 a year until year 32, and then their spending goes down. And what they have in year 20, when the first spouse dies, is a mere 935 million of investments and a $10 million residence. And on the second death in year 32, they have 1.5 billion of investments and an estate tax of $603 million. That would be a big check to write. Once had a 99-year-old client call my bookkeeper and said, I just broke my arm. And she said, how'd you break your arm? I just wrote you a big check. It broke my arm. It was kind of cute. All right, so now they could, and by the way, what does this look like? This is the estate tax imposed on their assets each year that they may die. So if they both die here, the estate tax would be 253 million, but the estate tax is a bigger and bigger part as they go. So they could fund a bypass trust on the first death to use the first dying spouse's exemption amount. Big deal, right? So I click on bypass trust, and on the first death, the 15,520,000 is what the exemption would be in 20 years based on inflation. It'll be 26 million on the second death. That's what it'll grow to, and the estate tax will be under 600 million. So I'm going to put the bypass trust in the document, but it doesn't do much. The qualified personal residence trust. Now the home, instead of being 16 million in their estate when they die, it'll be 16 million out of their estate when they die. And then if they pay rent at 8% a year of the value of the home every year from year 11 through the end of life, there'll be another 28 million out of their estate. So that actually, the Cupert may be worth actually doing. You know, without the Cupert, the estate tax is 599 million. With the Cupert, it goes down to 581 million. Is it worth 19 million to do the Cupert? You know, maybe not, maybe. But I got to show off the software and show you how the Cupert works. So then the annual gifting, I mean, 18,000 a year per child. What difference does it make when you make $30 million a year? Are you going to set aside $18,000 a year per spouse per child? So I will click on the annual gifting, and you know what? It's a bunch of change. You know, based on the numbers I showed you, the number of giftees. And by the way, when you use the software, when you click on the right button, the left input shows up on the left. And now this gift trust, just based on 216,000 a year of gifting for 20 years, inflation adjusted, has 17 million in it on the first death, 50 million on the second death. That's that time value of money. That does add up. So I would say the annual gifting is worthwhile. We could even make it better, because what we said here was they could gift not only stock but an LLC interest, take a 30% discount. So if I click on discounted gifting, now it shows 72 million. You know, even if I was a wealthy kid writing a check to Uncle Sam for $553 million when mom and dad died, I wouldn't mind having 72 million in a gift trust. So I think we do that one. Then, by the way, let's look at the timeline now. So the timeline is these tiny little trusts down here. The green and red is their main assets. The yellow is the qualified personal residence trust. The brown is the second qualified personal residence trust. The blue is that gift trust. And the red is the estate tax. Remember the Red Baron and Charlie Brown, for those of you who are old enough to admit it? Okay. So then now we're going to do they do the large gift? Now, I'm not a big proponent of the large gift because I want to do some other stuff with them that may arguably use their gift exclusion, but they may want to do a large gift. So I click on large gift, and now that gift trust, before the large gift, that gift trust went to 72 million. It went from 0 to 25 million in year 20. Year 32, it went to 72 million. Now we're going to throw 26 million in it. So, and they're going to pay the income tax on that trust. So it's going to grow tax-free. So I click on large gift. Now it starts at 30 million. That gift trust has $192 million in it. And that is just a gift without discounts. That was just a gift of $30 million that they make. So what if we used a discount? Large gift to trust. Oh, I'm sorry, they're using a 30% discount. If there was no discount, let's get rid of the discount. If there's no discount and they make a $26 million gift, then the gift trust is worth 174 million. But if we take a 30% discount and we actually are gifting 35 million to an LLC, gift the 99% interest at a 30% discount at 24 million. Now that gift trust is up to 216 million. The estate tax is down to 500,000, and the descendants are getting $1 million. So we started, let's go back to where we started. We started with no planning, 600,000 estate tax, 946 to children. Now after all this stuff, we are at 553 of estate tax, 996 to children. I don't think they're impressed yet. So now I want to go ahead and do an installment sale. So this is an installment sale, not of their business that's helping to pop out 30 million a year, but this is just an installment sale of $65 million of investments under an LLC. They make a $4.5 million seed capital gift to the gifting trust, so they have a 10% down payment. They sell 99% of the LLC to the gift trust for a $45 million note at 4.47% interest. So we're taking about $20 million off their net worth initially. We're turning an asset that's growing at 7% into an asset that's growing at 4.47%, and we're having them pay the tax of 2% of the value of these assets every year from their personal assets, and letting the installments note pass estate tax free, or I'm sorry, having from their personal taxes to reduce their tax. So when I click on installment sale now, you see the installment sale trust with $267 million in it at the end of year 32. So you see at year one, it's got 70 million of net worth minus a note of 45 million. So with all our hocus and pocus, we've gotten 24 million out of the estate. But that time value of money and having them pay the tax, this moves their estate tax down below 400 million and moves this trust up to 267. So now when they die, even without the rest of their assets, the Cuperts give 28 million, the gifting trust is giving 216 million, so that's about 250 million, and then the installment sale trust doubles that to 267 million. And this may be fine for them depending upon how charitable they are, but most clients would like to do a little bit more. So what I can go ahead and do just to have discussion on this is think about putting part of their business into the installment sale. So I could, if the business is generating 30 million a year, let's say that would be times 5, $150 million value. Take a 30% discount, 33% discount, 100 million value for the business. 1/3 of that would be a $33 million additional sale. So I can go from 65 million to, let's say, 95 million on the sale. And then I can show that the installment sale income would be 10 million. So now 10 million of what they were receiving, 20 million, now 10 million a year is going to the installment sale trust. And the result is quite good. First, the installment sale trust has a $35 million net worth. After 20 years, it's got a 574 million net worth. And actually there's zero estate tax and their assets wipe out. You would have to toggle off grantor trust status. Let's look at this from a timeline. There's that installment sale with only 1/3 of their business, 10 million a year of the 30 million going into that installment sale. There it is. There's the estate tax. And look at this. That's where they run out of assets. They actually run out of assets. So this thing, it can be very powerful. But of course, they're worried about dying sooner rather than later. So, but my gosh, that's pretty useful. Let's now look at how much they would leave to charity. Because remember what I said was they don't want to pay any estate tax, and they may die earlier. than 32 years from now. So looking at the timeline, in fact, let's just, well, I can show it to you from a timeline standpoint. Now, when they die, I can click on testamentary charity, and their excess assets that would have generated this red estate tax will go to a charitable lead annuity trust. Now, what is a charitable lead annuity trust? It's a trust that pays to charity every year for a number of years, and what's left at the end goes to the children, even though it qualifies for a 100% estate tax charitable deduction. So I'm going to want a 100% estate tax charitable deduction to zero out federal estate tax, and I'll click on testamentary charity, and I'll assume that it'll pay to charity for 20 years, and what's left at the end of 20 years will be 40% of what's going into the CLAT. So I click on testamentary charity. So you see what happens. A little bit of red going to the IRS becomes a lot of purple going to charity. So the children may not get as much as they want the children to get. So I'll go back to logistics here, and I'll go back in time, and I'll kill them off earlier so that we see some estate tax. So I'll kill them off in 2039. So in 2039, with the installment sale, you only have 120 million of estate tax. The descendants are getting 652 million, and that's in 15 years by shifting that 10 million a year of income to the installment note. And then to zero out that estate tax, I click on testamentary charity, and now what happens is the kids get 471 million on the second death. The charitable lead annuity trust gets 301 million. Then their charitable foundation over 20 years gets 181 million. And what's left at the end of the 20 years is another 120 million. Of course, we don't take into account the time value of money in this illustration, but the kids end up with 592 million. It cost the kids 60 million to fund the charity for 181 million, but nothing went to the US government to pay them to make more regulations. So now, I think my clients are very bright. I know they're very bright. I think they might understand a lot of what I just said. So I'm going to click on Generate Client Letter, select all scenarios, and Generate Client Letter. And now it's preparing a letter that I'll be able to share. If any of you want to read the letter that describes the step-by-step planning of each of those techniques, just let me know. And there's the letter. See if it worked. It always works. And enable editing. So there you've got the inputs and the outputs, and it, works pretty well. And then before I forget, I'm going to share this exact piece of software, this module. I copy that to the clipboard, then I open an email, and I won't share my emails with you, but I'll go ahead and send it right now as an email, so that if you want to play with this particular module, just send me an email and I'll send you the clip, and you'll open your email, click on it, and go to 832-728 will be your code to get you into that. And that's how I'm going to talk to the clients about that particular estate after they watch the video. Let's see if there's any final questions here. I want to thank, oh, by the way, the CLAT calculator is where I would go to run the actual numbers on how the CLAT would work and how many years you go and whether you take discounts and how you get the most to the children. and the lease to charity, still getting 100% charitable deduction, and you got a Cupid calculator. Okay, any other questions? Somebody said, sorry, they have to go. Okay, can I speak on LLCs that make S elections? Yes, it's very confusing to people, a lot of people, but an S corporation can be an LLC properly drafted that makes an S election. An LLC can elect to be treated as a regular corporation, but you have to be very careful, Carol, because if you have the wrong operating agreement, the S election will not work. Okay, Lusamar, I'll be sending you the name of Mr. Gutierrez in Colombia. There's 1,000 Gutierrez's in Colombia, but this particular Mr. Gutierrez has done a nice job for other clients. Rob, thanks always for attending the webinars and for your friendly words and encouragement. Very, very, very appreciated. Thanks to everyone for your contribution to this series of webinars. I hope that you will use the information that we've provided you to help others in the best way possible. Thank you, Brittany and Debbie, for working on my slides, for all my last minute changes that I always make. And welcome your questions, comments, and suggestions. If you're interested in going to the Notre Dame Tax Institute in late September, Brandon and I will be there speaking with Jerry Hash and many others. We're going to do a promotional video on that later this afternoon with Jerry and Marty. If you have any questions, comments, or suggestions on that, let me know. And otherwise, that's it for today. Have a fantastic rest of your weekend. Thank you.